Thank you for listening to Lone Star Community Radio. This program was broadcasted and recorded live from the LSCR studios in downtown Conroe, Texas. Lone Star Community Radio is supported by listeners like you. Donate and sponsor today. For more information on getting involved with Lone Star Community Radio, contact us at lscrstudios@gmail.com or visit us online at www.irlonestar.com.
Hi, welcome to the Legal Connection Show, and I'm Toni Collins, an attorney in Texas, and our show is to help the general public and the citizens of Montgomery County and the surrounding area, and you can hear us on FM radio if you are within the radio band, and that will be on FM 106.1 or FM 104.5, and we air every Tuesday between noon and 1 on legal topics that people are interested in. And if you miss the show or want to re-listen to a segment, you can get us at irlonestar.com. They are recorded. Or you can put the Legal Connection Show in Google, and you can get us on YouTube. Or you can go to the Legal Connection Show Facebook. And all of our old shows are on there, too. Today, we are going to do something that's really important at this time of year to many citizens, and that's property tax protest. And all the property values have just skyrocketed because, I guess in part because of COVID, and everybody wanted to stay at home. I have no idea why they skyrocketed last year. I'll have to look. And, I'm in my graduate program at A&M, and I should know exactly why they skyrocketed. And I never can remember. I just know that they did. And everybody is complaining. And the tax appraisal boards are overwhelmed right now because people that want to fight and say their taxes really aren't as their property values are not the market value that the tax appraisal office has assessed certainly can't be right. Now, there is one important thing that I tell all of my clients that come to me about their tax valuation issues. And because, if your property's taxed more, your taxes are going to be proportionately that much higher the next year. And whether it is escrowed by your mortgage company, you pay it direct, it is a hit. And it's something that's really important. Now, in Texas, you can't, and I'm kind of getting off the beaten point of what I'm trying to talk about here. But basically, if you don't pay your taxes, the taxing authorities, whether it's the school district or the county, or there's a litany of them, but usually it starts out with the biggest one, and I think that's school, and we'll look at that in a minute. But they can file a tax lien, sue you, and basically foreclose on your property. It's one of those three things that will allow the government or an entity to foreclose on you if you don't pay your taxes. And if you don't pay them for 2 years, you don't have the money, for some reason you can't work something out, and it gets sold at the courthouse steps on on a particular the first Tuesday of the month that they alert you it's going to happen, then you can actually redeem it within a 2-year period per the Texas statutes by paying the taxes back to the person that bought it plus 25%. And so you can still get it back, but they own your property subject to you not redeeming it within the time frame. And it's just really not worth it. The taxing authorities will work with you on paying and that kind of thing. But to make sure that doesn't happen, if you've budgeted a certain amount of taxes for your real property, then you can protest your taxes. And that's what we're talking about today. I will just give you a little scenario that happened to me so far this year. I protested my taxes in Harris County. Actually, they weren't mine. They were for a client. When I went to go protest taxes in Harris County, it was kind of difficult because I'd protested my own there before, and I couldn't get an account set up. I couldn't get them to recognize me as not the owner, but someone that would step in and help them. You don't have to be an attorney to step in and help somebody protest their taxes, but you have to let the taxing authority know that you can represent them. And so because I'm an attorney, I've done this before, I called them, and they never answer their phone. It just rings off the wall. And then, I take that back. I emailed them thinking it would be easier to have a footprint. And they do answer their phone, but you can't rely upon what they tell you when they answer the phone. So you're going to get some clerk that makes usually minimum wage. And they're just taking calls in, and they've got probably like a list, like a telephone solicitor of, that works, a telephone solicitor that's working for somebody. They probably have a list of commonly asked questions and their switchboard. And they kind of they direct you to where you need to go or answer your question like one of those robots on the chats, that you get on the computer. And so I had called because I didn't get a response to my email and asked them how I needed to be able to get into an account to file a protest and represent these people. And the person I talked to, I got switched around a bit, said, just if you've already got an account, which I did because I own property in Harris, then go ahead and just file a protest under your account and add that address to it. Okay, sounds kind of complex. It's really not that. I had an account, I opened it up, I wanted to file a protest, I just added it to my account. So I went ahead and I requested the informal hearing, which you always want to do because it gives you the first shot at what they're looking at and what their records say, and just a ballpark. And it may be that in the informal hearing you get exactly what you're looking for. You don't have to go further to a more strenuous and I guess it's the more formal it gets, the more stress is involved in how you present it. But you want to do it. You want to do the informal if you can. They say you don't have to before the formal, but just do it. It's a good sort of protest experience that you want to have, and kind of gives you a heads up on how to do it online. And I always do the Harris County ones online, and because I've done the Montgomery County always in person. Harris County I've done online because it just takes so long when you go to Harris County. You're in this big old auditorium of people, and you get a number, and it's just like they're pushing you like cattle through. So Zoom is pretty easy. You're basically on hold for a little while. They tell you with a little number count on the bottom how long you have to wait, or if they want you to call back. But you do need to check in within an hour before, or within the hour. There's a 2-hour window. Or you miss your protest, and you may need to file a motion for, I guess, a new trial if you miss it, but you don't have to go to the informal one. So anyway, when I did this informal one in Harris County, I didn't have I did the request for the House Bill 201, which we'll talk about a little bit today, so I could see what records they were using to establish what this new value was. And I'd done my homework. I'd gone into the different marketing websites that were available to assess what were the closest comps in the area, which is pretty much what they use, that had sold from, for this year, it would be January 1st, 2020 through December 31st, 2020, because they're 2021 taxes. And they'll give you a little leeway if something was sold after that, maybe in January 2021. But anyway, you have to find comps and show why your comps are better and why it should be lower. And then there's various other things you can argue about the value and stuff, and we'll get into that about, the condition of the property and what have you. But so when I got on there, I was ready to go. I was very prepared. And the guy said, well, we don't have a representation notice for you. And I said, well, I talked twice to the Harris County Appraisal District personnel that I was referred to. And they said, I didn't need that. And you can see by my protest, it's my name, my phone number, my email address. I've zoomed in. You gave me the notice. It's me. And they said, basically this, and he didn't even live in Harris County. He was just somebody that had been hired in at lived in Fort Bend. He said, none of that matters. I'm not going to hear your case. Let me ask my supervisor. We need to get a letter of representation. And of course, I couldn't get my client on the phone within, a 10-minute time frame because it was unexpected. I would have to have gotten him on the phone, completed a notice of representation, which I'm an attorney, so it would have been that hard to do. Have it signed by them. I could have lied and signed for them, but I didn't want to do that. And I wanted to be, honest. I didn't want to jeopardize my integrity by, signing something without having their approval. Although I already had the approval, I guess I could have signed with permission, but I didn't do that. And so I said, they wouldn't let me reset the informal. They said, well, you're not a representative. We're not letting you go forward. So that's the kind of thing. That's why you want to go to the informal hearing, just to make sure that you've covered all your bases. And in doing so, it allowed me to kind of get with it and file the documents that I had prepared for that hearing, which I hadn't filed yet, and also the notice of representation. So it's just a good way to kind of get you going and get you ready for it. And again, when I talked to him, as well as when I've talked to people in the different representatives of the different county appraisal districts, they are overwhelmed this year because everybody's property doubled or either went up by 50% up to 100%. So you do want to protest these taxes. And that was my experience so far this year. My experience last year was very good. I went in person, protested my taxes in Montgomery County for the different properties that we own, and was successful each time, not at the informal level, but at the formal level, which I went to in person. And I was extremely prepared. I knew what to expect, which is good going into it, so it's not overwhelming. But these are, we're going to talk about who are the people that make up the appraisal review board that's actually looking at your property. And they're really, really nice, but they've got like they're citizens, they're a group of citizens. They're not hired, they're appointed, and we're going to get into that a little bit too today. But really, really nice group of people. And they look at it from the standpoint of not the appraisal district, but as a standpoint as a citizen. So there, you kind of start out with people that are on your side, particularly in the Montgomery County Appraisal Board. So what we want to do first is I'm going to tell you, rather than just, blabbing stuff to you, I'm going to give you some information that you would otherwise have to look up, and you might be able to be driving down the road listening to this and not have to look up at all. It is from the Comptroller's Office and from the state of Texas, and it just talks about your rights, and it's, they have Texas law help and various things that they offer in the government that you can just pull up and read, and it's really easy, but I've done that work for you, so I'm going to read to you some of the stuff that you need to know. All right, so this is from the Comptroller's Office, and it's called Property Tax Assistance, and it's basically, this one is the frequently asked questions, and this other one that I was going to read to you was more of a sort of generic overview, which I think I like that one a little bit better to get started with. Okay, so here you go. One of your most important rights as a taxpayer is your right to protest the Appraisal Review Board. To the Appraisal Review Board. And because the appraisal district is the one that assesses what the value of your property is, the Appraisal Review Board is the group of people that's actually looking at that you are confronting to have them reduce the value of your property so your tax will be lower. If you're dissatisfied with the Appraisal Review Board's findings, you have the right to appeal the Appraisal Review Board's decision. So this is after you've actually filed your protest, and the Appraisal Review Board of group of people said, nah, we don't agree with what you've come up with. We like the appraisal district's information better. You haven't sold us on it. We're going to keep it the way it was. Okay. This goes on to say that any Appraisal Review Board decision can be appealed to the state district court in the county in which the property is located. So now you're going an even higher level. The first course of action in the the pyramid of things that you must do is that you get your tax notice in the mail, and it says here is what we've decided that your property is worth this year, and you have the right to protest it, and you can do this online. And they kind of give you a guideline of how to do it. Do it online. It's the easiest way to do it. You just go to the appraisal district where your property is located. You can always find it by just putting your name in or the property address. And if you've inherited property, maybe you didn't know how to do this, but it's pretty simple. And you go in and put your name in, and you find your property in your account, and they've got usually a little iProtest icon, and you just toggle it, and it opens up to do you want to protest it? And you usually have to do it within a certain period of time from when you were given the notice. And that may have passed for a lot of people because a lot of the deadlines were May 31st. And I think in some of the outlier counties, it was up to June 6th to June 15th. So you may have a little time now. If you missed it, you might be able to actually appeal missing the deadline, which I would probably do if it's that important that you be able to protest your taxes because they went up so high this year. So anyway, at that point, you can go to the informal hearing and then state your case. And if you are not satisfied with what you get there, and I've not been in any of the counties so far that I've been to, but they get pretty close. And they all know each other too. So you want to be really nice to the person that you're doing the informal protest with because they see each other in the hall. And if you're not nice to that person, they will probably pass that on to the appraisal board that you're going to talk to next. So always be kind to everybody. All right. So any appraisal review board decision can be appealed to the county court. And I don't think you can do it in the JP court, which would alleviate the cost of having to actually file the petition. I don't know that when you file an appeal to the state court for a decision to the appraisal review board's decision that which would be against you, you wouldn't be appealing it. I don't know if you'd have to file. There's cost to that either because it's a right against a government entity. So I'd have to look into that for you because I really don't know at this point. But you would appeal it to a district or a county court. And if you do that and there is a cost, there's the fee to file that if it's not waived because it's an appeal of or in that nature and genre of things, then the price, the cost to file it is going to be probably somewhere in the neighborhood of about $160 forward. So you want to assess if your tax savings or if your information is good enough to be able to go forward and actually win that case, or you're just spinning your wheels and you're wasting money that you won't be able to get back again. All right. Depending on the facts and the type of property, you may be able to appeal to the State Office of Administrative Hearings. And their little code letters are the SOAH, or to a binding arbitration. So it's all, you have three different areas that you can go if you don't like the appraisal review board's decision on your property, which means basically you'll be paying higher taxes. Now, if the appraisal district appraises your property at a higher amount than in the previous year, Texas Tax Code, Section 25.19 requires the appraisal district to send a notice of the appraised value by May 1st or April 1st if your property is a resident's homestead, or as soon as practical thereafter. And that's what we're just going over. So this is just sort of reiterating. They don't send it to you if it was lower, but you're going to get that notice probably all the time now if it's going up. And if you've got a residential homestead on it, there is a 10% cap. They cannot raise the value no matter what's going on around you each year more than 10% than it was the year before, because that's your benefit to having it homesteaded. And I tell a lot of my clients that if they don't already have a homestead, but they happen to have property because they inherited or whatever, go homestead it, move on it, get on there, live on it 6 months out of the year, put a trailer house on it and rent it and call it your homestead. Do something, because getting that homestead during times like this is really, really important because it caps how high that value will go. Okay, so it's really, really critical. In the regular instance, a case that I was working on for one of my clients recently, he didn't want to homestead it. I think that the property was actually owned by his parents, and his parents had put in some kind of conditions on giving him the property, although it's really kind of his through family, because they wanted to give the final word on who he marries, and he didn't want to give him that right, and so consequently he gets to live in it forevermore and pay the taxes, but it won't be in his name. Therefore, it can't be his residential homestead, which is going to cost him a lot in the long run if he doesn't work it out with his parents. All right. The notice of appraised value includes information on how to file a protest, as well as an explanation of the availability of an informal conference, which is the informal protest, with the appraisal district prior to your formal appraisal review board hearing. And I'm going to start calling that ARB because that's what they're calling it in this little printout. The appraisal review board is the ARB hearing. So if you hear that, that's what that is. If you are dissatisfied with your appraised value, or if errors exist in the appraised records regarding your property, you should file a Form 50-132, a notice of protest with the ARB. In most cases, you have until May 15th or 30 days from the date of the appraisal district notice is delivered, whichever is the later date. Property owners and lessees may appoint someone to represent them in handling hearings concerning their property. Form 50-162, appointment or agent for property tax matters, should be filed if you elect to designate someone to represent for the protest hearing. This is news to me. I wish I had read this first because I filed just one of my, attorney created notice of representation forms. But they've actually got a form. If I'd known that, it would have been fill in the blank, sort of toggle in, fill in, and then file it kind of forms, and then you scan it and file it with them. So the Form 50-132 is actually in the tax I protest appraisal district site, so you don't have to file it in person. But this appointment for agent, I haven't seen it on this side, so I guess you do. And I'm going to look that one up because I represent a lot of people, but I've just never been asked for that before. Okay, so after filing your protest, you will receive written notice of the date, time, place, and subject matter for a formal hearing with the ARB. They typically will send that to you email if you filed an I-protest. You can ask for it to come to your house, but if you ask for it to come digitally, they will not only text it to you, but they will send it to your email, not once, but a number of times. So I kind of like that because they remind me, if it doesn't go to your spam, you get to hear about it. But you can ask for them to do it all three ways. They're pretty good about informing you about when your hearing will be. Now, you may request an informal conference with the appraisal district to try to resolve your protest before the ARB hearing. If you're not able to resolve the protest informally, you can continue to protest to the ARB. At the formal hearing, the ARB listens to both the taxpayer and the chief appraiser. And usually the chief appraiser is kind of aligned with you, almost like a courtroom table, but it's in a little room. And they're just another person who's representing, is paid by the tax appraisal district, who's got their information in front of them. And they're pretty good friends with the appraisal review board. They're all sitting in this room together, and you're the odd man out. You come in, and it's almost like the district attorney, the prosecutor when you go to a criminal court. They're friends with everybody in the court because they're there all the time. And you come in, and you must be prepared. It's your burden to show why the appraised value is too high. At the formal hearing, the ARB listens to both the taxpayer and the chief appraiser. You may discuss your objections about your property value, exemptions, and the special appraisal in a hearing with the ARB. The ARB's decision are binding only for the tax year in question. So you have to keep going back each year if it goes up each year. What I will tell you is that when you go to the informal hearing, and many times even in the formal hearing, you can hear what's going on in the other rooms while you're waiting. And you hear the pleas by the taxpayer to their chief appraiser, because the whole bunch of them are going on at once. And what I hear most often, which I just want to go in there and help them, but usually they kind of usher you in and usher you out, and it's really kind of not your business because it's too late for you to gather information for them, and certainly they can appeal what they're arguing. But you'll have somebody in there arguing, my husband had a heart attack, my COVID, it's been, he lost his job, I've lost my job, we've been hard times. They're talking about why they couldn't pay their taxes. They're not arguing the tax value. That is the inappropriate and improper argument. You will get nowhere arguing why you couldn't pay your taxes. You may get somewhere on the condition of the property, but this will be of no help, and you're just really spinning everybody's wheels, and you're never going to win that way. So you really want to go in prepared with comps that show why, and comparables, other sales that would happen, that have occurred, that can be legitimate and verified between January 1st, 2020 and December 31st, 2020, that are close to your property, and you can show why your property should be valued at where this other valued property is. That's the only way, short of the conditions or exemptions that you weren't provided, that you probably are going to be able to be successful. And I have been successful, and I'm not that smart, so you should be able to do this too. If you lease property and are required by the lease contract to pay the owner's property taxes, you may protest the property's value to the ARB. You may file a protest only if the property owner does not. The right to protest applies to leased land, buildings, and personal property. The appraiser district will send the notice of appraised value to the property owner, who is required to send a copy to you if you're leasing the real property and you're paying the taxes. You may request the chief appraiser send the notice of appraised value to you as a lessor if you are contractually obligated to reimburse the owner for the taxes imposed on the property. If you protest, the ARB will send any subsequent notice regarding the protest to you. The comptroller's office is prohibited from advising a property owner, agent, or appraisal district about a matter under protest and from intervening in a protest. So, I'd kind of be like crossing the line if I was hearing somebody that was really struggling saying, hey, I want to step in here and help. Because I guess you could do it, on the floor, so to speak. But I don't know that I would ever do that. I would probably tell them after the fact, here's what you need to do to appeal. Once the ARB rules on a protest, you will receive a written order by email or certified mail. Counties with populations greater than 120,000 will deliver the notice of order and a copy of the ARB survey by email if a written request is submitted to the chief appraiser and the property is not already a part of an electronic communication agreement with the appraisal district. So again, once you file to protest, they're going to ask you, can we communicate with you via email? And once you say yes, you are now in the email or digital communication, and you don't have to worry about that. I will say this: when I won my protest in Montgomery County, I know the day that I'm leading that protest if I've won or not. And they asked me to sign a sheet of paper right there, agreeing to the amount. It's almost by agreement. This is what is going to happen. Do you agree to this? So it's kind of almost in settlement, but I'm signing a piece of paper, and then within a week, maybe 2 weeks, I'll receive a piece of paper. It's a document, almost like a contract from the appraisal district, explaining that the review board has determined that the value of my property is whatever it was, and I've already agreed to it, so I knew. And then my taxes will be adjusted to that new lower appraised value. It's only good for that year. You will get one the next year, because the next year, once again, you're going to have the appraisal district showing some phenomenally high value that you were not successful in. You'll have to go again to argue each year. With commercial properties, if this was sort of a surprise to me, one of our commercial properties had a really high valuation. I just hadn't really been paying attention to it because, I knew property values were going up, but I decided to argue it last year. And it ends up that the commercial values that I could prove the sales for were considerably lower than what we were being taxed on. And they lowered the tax value lower than it had been in for the last 5 years. And I guess I could have asked that the value be adjusted for those 5 years, because I could have go to county court and it would be, you have a 4-year contractual statute of limitations to bring a suit. But the time and the effort that I would have had put forth and the tax saving were not, it wasn't equitable for me to do that, because there would have been a cost in filing the suit and waiting for the suit to come through. And I would have won, but it just wasn't, I assessed that it wasn't worth it to me to go ahead and do that. But you can do that if it's worth it. So also do that economic assessment. You must request email delivery in writing and provide a valid email address to receive appraisal district notices electronically. If the ARB rules in your favor, it will instruct the chief appraiser to notify the taxing units, all of them, whether it be the MUD, the school district, all that little list of taxing entities that charge you, about the change. If you pay the taxes, the taxing units will send you any refund resulting from the change on the appraisal roll. So you don't need to hold off and accrue interest on paying your taxes. You can, because you'll still have that penalty even on the lower amount. So go ahead and pay your taxes, but you'll get a refund on the value. So I think that's always wise to do. The ARB must send you notice of the date, time, place, and the subject matter of your hearing at least 15 days in advance of the hearing. At least 14 days prior to the hearing, the appraisal district must send you the comptroller's property taxpayer remedies, the adopted ARB hearing procedures, and a statement to inform you that you can request copies of the information the appraisal district will use at the hearing. This information and the notice of hearing are often sent together. When you request the information that they're using against you, this is like discovery, you can do it formally by just asking for what they're using through what's called a House Bill 201 request. I generally do that. I didn't even know about it until my friend and client, Crystal Ward, told me this is what you need to do. But the House Bill 201 that you notice, you'll get an extensive list of information that you've got to weed through and dump in Excel and put together and pull back out again and look at, because particularly on a commercial property, they give you all the different classes of the buildings and all this different stuff. So it's kind of complex. When I asked for it from Harris County, I got something really small, and I knew it wasn't the information that should have been provided to me, because I could see what the other counties were sending me. So you should ask for it through the notice that they send you, but you should also ask for it through just a little 1-page, 3-paragraph letter that's called the House Bill 201 request. And the House Bill 201 was the state law that required that they be able to provide you with this information. So do it both ways. And you can send it via email, and you can file that request digitally in the different appraisal district accounts where you're asking for it online. I've got, I think, 4 different counties I'm kind of juggling right now. I've got Waller, Grimes, Harris, Montgomery, actually 5, and Fort Benton. So I'm kind of doing a bunch of these. And they're not really hard if you do them via Zoom at all. And if you got an attorney like me that is doing it for you, and I say that because a lot of my friends, they're not getting paid for doing it, so it's a lot of work. Once you get sort of the routine down and doing it, it's very efficient. So you get these taxing companies that will sign you up every year to protest your taxes for you. And a lot of times they're exactly who you need, but you need to be careful because they will put you on one of these automatic renewals and you owe them every year. And it's like a lot. You don't get charges they don't reduce, but they can usually reduce it by $1. And then that $1 charge may not cover the cost of the benefit you got, so you're still losing money. So you have to be really careful about what you're signing up for and how much they can reduce your taxes before you sign up for it. But it may be worth it. They do it all the time. And just kind of be careful, though, because if you're on one of those renewed contracts, and it could be good this year because everybody's taxes went up, you may forget about it, and they're always right there on the money to do it for you. But I don't like to do anything that's on a renewed basis like that because I've got too many different things going on, and I would forget, and then I'm charged, and you can't get out of the contract. You have another contract dispute, even with the taxing group that's helping you. So anyway, little sidebar. You can appear at the ARB hearing in person, by telephone conference, video conference, or by filing a written affidavit. So if you just want to send in what you've got, you don't even have to, if you're sort of shy, you can do everything by affidavit. I like to be there in person just to talk to people so I can argue with them a little bit, to kind of see where they're going with it, because they might have misinformation about my particular property. In Montgomery County, they actually bring your property up on Google Earth so you can kind of look at what's going on. It's kind of nice because if you're not completely prepared, you can kind of see what's going on. And do go to Google Earth Pro. It's a free program, free application, and you can actually put in that Google Earth Pro, not just Google Earth. It's got like a little clock in it, and you can move that little clock up and down to every time there was a satellite picture, and you can watch the development of your property, say, pretty clearly from about 2008 forward. But anything before that, it's kind of sketchy because satellite pictures were not as good, and sometimes they're blurry. And when you get back to like 1945, when satellites were pretty new, you got this really blurry stuff going on, but at least they've taken a picture of your area. But it's kind of fun to do that. You can also assess what development has gone on in your area, whether it be good or bad, to determine what might be your best comps. You can actually see it. And I'm kind of visual in that respect, and so it's a good thing, a good tool to have that's free that you can look at. Google Earth Pro, go to the little thing that looks like a clock. It'll bring you the history. You can literally put that little cursor right on your property and then move the history timeline, and it shows you like the time machine, your property evolving. It's really kind of fun to look at, too. The ARB hearing procedures may tell you how many hard copies of evidence you may need for the ARB, or panel members, or what electronic devices may be acceptable for presenting your evidence electronically. You should become thoroughly familiar with the ARB procedures and adhere to them. They're very, very nice at the ARB hearings. Even if you have not timely filed this stuff, many, many times, if you bring the proper copies with you, they will let you present them. Even on the day of the hearing, they let you present them. So if you're pro se, and even with an attorney, it's kind of pro se, so it's kind of liberal, don't, just because your hearing is the next day, give up. You prepare for 5 hours, whatever it may take. Usually it takes me about 6 hours to, really about 10 hours. It takes a long time to really prepare for them to have a good argument, or you're going to lose. You don't want to go up with fighting somebody that's got, machine guns, and you're with a, pocket knife. It's kind of the way the evidence would be presented if you weren't prepared. So probably a bad analogy, but do be prepared. You want to be on the same playing field. Be on time for your hearing. Be prepared. ARBs try to conduct hearings as informally as possible, but they should be treated with the respect you would have in a court proceeding, because it really is affecting your property just like a court proceeding would. Confirm the date, time, and the place of your hearing, and arrive on time, or earlier possible. And that means if it's online, log in on time. In case you have some problems with how to connect and that kind of thing. Counties with populations greater than 120,000 will deliver an electronic reminder of the date, time, and place of your protest hearing if you submit a written request and provide an email address or telephone number where a text message can be sent. You are your designated agent, and the appraisal district representative will both have the opportunity to present evidence, examine witnesses, and state an opinion of the property value, if applicable. And you may elect whether to present evidence first or after the appraisal district representative presents their evidence. I'm kind of on the fence on that. If they're going first, it's the first thing that the appraisal district gets to hear, and so they may be tainted by it. On the other hand, I'd like to kind of hear what they say, and there's really not a time limit on this stuff. So I guess it'd probably be in your best interest to quietly and politely hear what the appraisal district the chief appraiser has to say, because it kind of lays out what their argument is, and then you can be ready with your ammunition to contest each and everything that they say, particularly if they've got some of their facts wrong. With regard to exemptions or property that they've used or the condition of your property and that kind of thing. I do know that you can't just go in there and say, well, I don't know, what do you think it's worth? You really have to have an amount in mind, because the appraisal review board is going to say, what do you want? You can't go in there and say, well, what do you think? You need to give them a number, because they've got a lot of these that they're doing. You just say, this is why it is this per square foot. This is why I believe this is what you need to use, and stick to it. If the appraisal chief, though, is even lower than when you argued, it's certainly in your best interest not to open your mouth to hear what they have to say, because you've got a land value and you've got an improvement value, and if one or the other is lower from their standpoint, certainly take that and run with it, and make your little notes and don't be arguing for a higher amount. Okay, so you are your designated agent, and the appraisal district representative will both have the opportunity to present evidence. And then we just had gone over that. The appraisal, you can choose which one goes first. Take anything that will help make your case. It is up to you to have what you need to prove your case. You cannot go into the hearing and just say that the appraisal district is wrong. You should gather all the information about your property that may be relevant in considering the true value of your home, such as the receipts or estimates for repairs. That's really important to show that this place is falling apart. I have gone in with pictures of how it's falling apart, recent ones. You need to be honest. You don't want to lie about it. And then the neighbors, if you have comps on the MLS to show why they're sold for so much more, show that. The condition or the improvements of the property are very relevant to, and the age and all the other things that you would argue, to why your property should not be appraised, or the improvements to what it is. Land is a little bit more difficult. Usually I always have to go with comps of land, but certainly do that. I have a case right now where my client's property looks like it should be valued far higher than it is, because it's hard to find comps. But his property is right next to a running mortuary and a cemetery, and that's going to be far lower than any of the property values that were sold that were comps, because nobody wants to be next to a working mortuary. You've got hearses going back and forth, and crematoriums, all this stuff going on. No. So bring that information in. Use common sense. That wasn't argued before. It should have been argued long before, and that's my key argument for that particular case, is nobody wants a property that's got a crematorium and a mortuary next to it, literally next door, because it's going to be more of a commercial than a residential and that kind of thing. But anyway, I don't know why they didn't bring it up before. Receipts for estimates for repairs, very important. Bring those with you. Sales price documentation, such as listings, closing statements, and other information to show that their sales comps are not good. What if you just sold the property or just bought the property? Certainly bring that evidence in to show that it's lower than what their valued amount is, because that's what the market value is. That's going to have far more weight than some comp, because that's the actual amount and it's your property. You want to, they're going to say, well, this isn't valid. It didn't show up on ours. It's not on our records. You want to be able to have a witness to swear, I bought this for this amount. I don't know why you don't have these comps if they don't, because that's kind of what you're up against. Who's got the more credible evidence. Calculations of median level of appraisal, if equal and uniform appraisal is protested. Affidavits, if needed, which should be sworn by a notary. And, it may come to question as to whether it's forged or not, if the notary, if everybody was, if there was some bias. But the affidavits have a lot of weight. So don't discount that if you can't get somebody to come in time for your hearing. Do get an affidavit signed before a notary. Newspaper articles, architectural drawings or blueprints, engineering reports, property surveys, deed records. Part of your hearing involves evidence, and another part involves arguing your case. Arguing means presenting your case by a clear and concise presentation of your evidence. Do not get personal. You may feel that your taxes are too high, but neither the ARB nor the appraisal district set your taxes. While the ARB can consider the effect of the general economic and environmental factors that may have on your property value, it cannot take into account your personal economic situation. Emotional arguments or wishful thinking will not get you anywhere with the ARB, whose job is to certify the value of your home or property based on what the market dictates. And the how to present your case at the ARB hearing video is set up on the comptrolleroftexas.gov. It's comptroller.texas.gov's website if you want to actually see how it's done. Now, late filed protest. We talked about this a little bit earlier. The usual deadline for filing a protest is May 15th or May 30th, after the notice of the value was delivered to your property owner, whichever is later. Under specific situations, your protest after the deadline for filing a protest has passed. And we're right in that period right now, at being, I believe today's June 13th. But don't fear. You don't want to give up, because you can file for a late protest. You may protest failure to receive notice that the appraisal district or the ARB was required to send you. You must file this protest before the delinquency date, and you must not allow your taxes to go delinquent. And I always say pay your taxes. Don't let them be delinquent when you're arguing about the tax value, because you really don't have a very strong footing if you're arguing about the value of your property and you haven't even paid your taxes. You may file a motion for correction, and the appraisal district let me rephrase this. You may file a motion for correction that the appraisal district appraised your residence homestead's property at least 1/4 higher than its market value. You must file this motion before the delinquency date. You must not allow your taxes to go delinquent. You may not receive a hearing for this reason if the property was subject to an earlier protest for the year. All right. So if you're delinquent on your taxes, there's some wiggle room in there. But not much. Just pay your taxes. And then once you pay them, you may be within this window to be able to protest for the next year. You may file a motion for the correction that the appraisal district appraised your non-residence homestead property at least 1/3 higher than its market value. You must file this motion before the delinquency date, and you must not allow your taxes to go delinquent. You may not receive a hearing for this reason if the property was subject to an earlier protest for the year. Now, next, you may file a motion for the correction of a clerical error. Multiple appraisals include property on the, and the way this is phrased, it's really funny, so I'm going to read it again. You may file a motion for the correction of a clerical error. Multiple appraisals include property on the appraisal roll that should not have been included, or an error of ownership. This type of late hearing may include the current year and the 5 previous years. So you can file a late protest all the way back to 5 years. So I'm going to read that again. You may file for a correction due to a clerical error, multiple appraisals, including the property on the appraisal roll that should not have been included, or an error of ownership. All right. Now, the next, you may ask the chief appraiser to agree to a joint motion to correct. If both the chief appraiser and you are in agreement on the late change, then the ARB will approve the change. After you have filed the notice of protest, if you believe the ARB or the chief appraiser failed to comply with the procedural requirement relating to your protest, you may file a request for limiting binding arbitration to compel the ARB, the chief appraiser, to comply with certain procedural requirements. And you can visit it's the limited binding arbitration section of the Texas Comptroller's site to learn more about going into arbitration. And I will say this, if you are filing late, and this wasn't included in this printout, but I don't know why, but I'm going to add this, you can call the appraisal district's office and say, because they send it in writing, just tell them, they don't send it certified, I didn't receive a copy of my appraised value and the notice to be able to file my appraisal. They can't prove you received it, and you may not have received it. Call them and ask them to send your appraised value and to give you, to extend the deadline, the filing deadline, because you did not receive it. And there could be a number of reasons. You had COVID, you were in the hospital, you're out of state. They're pretty nice about that, and they are so bogged down and booked up right now with everybody filing their protest that they will probably grant your request for a late filing. You're right within that period right now. If you didn't protest and your market value, and you haven't even looked at it, is much higher than it was last year, and you feel that was wrong, call the appraisal district or email them and ask that you be able to file a protest even if it's late. They'll probably do it for you, so don't discount that. Now, let's say that the appraisal district board, you just didn't get anywhere with the informal appraisal district board or the ARB. If you're dissatisfied with the ARB's findings, you have the right to appeal the decision to the state district court in the county in which your property is located. Here in Montgomery County, you've got, I could be wrong here, but I'm going to say you probably have 6 district courts. In Harris County, you've probably got 50 district courts, so you have no idea what court you're going to land in. In Montgomery County, you're maybe in the 9th, in the 284th, in the, I want to say the 410th, maybe the 210th, but you've got like 6 of them. And we only have a few judges. So you're going to know which district judge you're going to fall into. And all pretty nice, all pretty fair. I haven't been in the district courts a lot recently, so I've been doing a lot more in Harris County than Montgomery County. But it seems like all my cases either end up in the 457th or the 284th. I don't know why, but they always do. So I know those 2 judges fairly well. Now, within 60 days, remember, time is of the essence on these appeals. Within 60 days of receiving the ARB's written order, you must file a petition for review with the district court. Before filing a petition, you should consult with an attorney to determine if you have a case. Otherwise, you're wasting your money and their time. And basically, it's the filing fees if you're doing it per se. You also are required to make a partial payment of the taxes, usually the amount of the taxes that are not in dispute, before the delinquency date. You may ask the court to excuse you from prepaying the taxes. To do so, you must file an oath attesting to your inability to pay the taxes in question and argue that prepaying the taxes restrains your right to go to court on your protest. The court will hold a hearing, decide the terms and the conditions of your payment. This isn't basically an inability to pay, is an indigency affidavit. And they're going to ask you, just like they do in criminal court, do you have a job? What are your expenses? They're going to ask you all the things that have prevented you from being able to pay these taxes. They may be more lenient with you than they are in even appointing an attorney to you in criminal court. They're becoming very strict in criminal court. If you even have a job, you can't get a court-appointed attorney. It's your right to an attorney. But because there's enough attorneys like me, and I'm all booked up, so don't get any ideas about asking me to do any more pro se, because I'm up to my neck in pro se at different cases. But if you can work out a payment plan if you've got a job, and these courts are not giving you, at least in Harris County, they are not allowing you to get a court-appointed attorney if you have almost any income, because there are so many jobs available out there right now that even if they're minimum wage, you could afford to have a payment plan with an attorney. Now, that may not be the case with paying your property taxes, though, so you still want to argue that it would be a hardship on me to pay these taxes for whatever reason. So be at least somewhat prepared and look that up, kind of Google it, and what it's going to take to make sure that I don't have to pay my taxes, if that's the direction you're going with this. The taxing board is usually pretty good about giving you the ability to enter a payment plan, though. So you might really want to consider that than going to wasting your time and energy, because time is the most valuable thing you have in life, because you only have so many days and so many hours of the breath that God gave you. So why would you be wasting it on arguing something that's a losing battle? You're going to end up paying the taxes anyway, or to some degree, some taxes. And as they say, the only thing guaranteed in life are death and taxes. Now, At the district court, you may ask to have your appeal resolved through arbitration by jury, a judge, or allowing the property owner to cure their appeal as a timely filed protest. You may also request that the parties engage in settlement discussions before the date of trial. This goes for any time you end up in the district court. I am a big advocate for mediation, going to, I believe it's the Montgomery County Arbitration Center, or I think it's Dispute Center is what it is. And they don't cost as much as a private mediator. Arbitration, of course, is just court, but private, so you're having to pay for the judge in that instance, too. So I would definitely go to the Dispute Resolution Center or a private mediator if they can give you a good rate on it to try to resolve your issues, because they're usually unbiased, fair, and they'll give you some pretty good advice. So go that direction first if possible. I think that's just, you're working it out sort of in a very, very informal manner, and you may not be able to work it out, but it gives you kind of a heads up of what you'll be arguing in court. So I'm all for that, and you should be too. You may also request that the parties engage in settlement discussions before the date of court, and that's going to be the alternate dispute resolution, and that's going to be your mediators or arbitrators. Now, if the property value as determined by the ARB order is over $1 million, you may be able to file an appeal with the state office administrative hearing. So that's when you can get into the administrative office. You may only appeal to the SOAH if the appeal concerns the determination of the appraised or market value of the property or an unequal appraisal. The option to appeal is applicable to determinations concerning real property or personal property, but not industrial property. To appeal an ARB order to the SOAH, you must file a notice of appeal by property owner with the chief appraiser of the appraisal district within 30 days, not 60, of receiving the order of determination from the ARB. You must also file a $1,500 deposit with the chief appraiser within 90 days of receiving the order of determination. That's because the property is of such a high value. As soon as practicable after receiving the notice of appeal by property owner, the chief appraiser must indicate, where appropriate, those entities in the records that are subject to the appeal. The appraisal district will forward the deposit and the notice of appeal by property owner to the SOAH and request the appointment of a qualified administrative law judge to hear the appeal. Now, I'm looking at this, and it says if the property value determined by the ARB order is over $1 million, you may be able to file your appeal, not with district courts, but the State Office of Administrative Hearing. And just as an aside, there is, because of the value of properties has gone so far up so quickly, there are many residential properties in Montgomery County. A number of my friends that have properties that are well over $1 million. $1 million threshold is not that much these days. So a lot of people might be considering going to the SOH, which is, I think it's, you have to put in the $1,500 deposit, but you'll get it back. It's just a deposit to make sure that you do pay your taxes. So that might be a good way to go. You might want to go to binding arbitration. An alternative to filing an appeal to the district court, you may have the right to appeal through binding arbitration. And I will just say, I'm the first one to suggest not doing that, because you're actually, rather than your taxpayer money going to a district court where you have to wait in line and what have you, you're paying an arbitrator, which has the same rules basically, but you're having to pay for the judge too on top of it, that the arbitrator is the judge. Binding arbitration is available for market or appraised value determinations by ARBs. Unequal appraised determinations may also be subject of a request for binding arbitration. Binding arbitration is available only if the property is a residential homestead, regardless of the value, or the property with an appraised value of $5 million or less. To appeal an ARB order to binding arbitration, you must file a request for binding arbitration with the appraisal district not later than the 60th day after receiving the notice of the order. A little bit different from the SOAH. You get 60 days again. To apply for binding arbitration, you must complete the comptroller's request form and submit it with your deposit in the required amount based on the ARB's determination of the property value and the property type. Although your deposit is made payable to the comptroller's office, you must file it along with the application in the appraisal district in which the ARB order was issued. So kind of like they're kind of heading the show here. The appraisal district will complete the application and forward your request in the deposit to the comptroller's office. Visit the arbitration section of the comptroller.texas.gov, and they'll give you more information on that filing process. And that basically covered all you need to know about appealing the appraisal, protest, and appeals. Next week, we're going to go over the frequently asked questions and a little bit more of the technicalities that you get into for it, to what you're really going to experience, and sort of a how-to on it, so you don't have to watch the video. And so tune in next Tuesday and listen to that part of this segment on tax appraisals. And remember, the most important thing that you can do in this lifetime and throughout the next week is to serve God by serving others. And so we'll see you next week.